Thank you. Before we start, may I kindly request Babe Templeton Dlamini to come and open this session for today with the word of prayer.
Can we please pray? Father God, we thank you for this time that you have given unto us to come before you to deliberate on issues of illicit financial flows. We pray, Father God, for your guidance and wisdom during this time. We thank you, Father God, that as we partner as different stakeholders, you are going to guide us, oh Father. I dedicate each and every item this day unto your hands. In Jesus' mighty name we pray. Amen.
Thank you, Mr. Dlamini. I'd like to observe protocol today. I'd like to observe that we have members of council present and we have our technical committee present today. And may I also recognize captains of industry who may be present and all our compliance, our managers, our executives from the industry, and all our invited guests. You're welcome to the second day of the AML CFT Indaba 2023. Yesterday we learned a lot. It was a very, very interesting day. We learned and we noted our weaknesses. We learned that in terms of the mutual evaluation report, as a country we've been found lacking, and we also noted that there's been milestones that have been achieved in terms of trying to close the gaps. We have a consultant on site who's currently assisting the country with an AML CFT strategy, and we also observed that the National Risk Assessment was already underway and is almost complete. A few weeks ago, we had the World Bank on site assisting the country with reviewing the risk assessment. And we're hoping that in the next couple of months it will be adopted. We also had interesting conversations and insight in terms of asset for future, and we know what to expect from law enforcement regarding anti-money laundering going forward. And we also noted that there's a lot of capacity building that needs to be undertaken in those that are involved with law enforcement, the police, the prosecution, and maybe the judiciary. So we're looking forward to imparting that information and making sure that our country is observing all best international standards in terms of combating AML, CFT, in terms of asset for future. Today we have two sessions. We have a half-day program. The first session that we're going to have is on ultimate beneficial ownership. The session is going to be a panel, a plenary session that is going to be led by Ms. Nomfanelo Kunene, and we are going to learn what is ultimate beneficial ownership, and I'm sure those that are working in the financial industries have an idea on what it is, but today we're going to learn more in terms of what is expected, how we open the layers, how we remove the layers, and to see the ultimate warm body who owns an entity. We have observed that in our jurisdiction we have those issues where there's a lot of layering in terms of ownership of certain entities. So today the session is going to take us through that program, and at this point may I kindly call on Ms. Nomfanelo Kunene to come forward to lead the first session. And may I also call on Mr. Msebe Malinga, the registrar, Mapalane wetinkampani. Mapalane lomkhulu wetinkampani takangwana. And may I also call on Ms. Tabile Mamba from the Central Bank. And may I also call on Ms. Hlopsile Langwenya from the Financial Services Regulatory Authority. We have two industry players who are going to be part of the panel. May I call on Mr. Pindamandla Twala from the Bankers Association. And may I also call upon Mr. Simanga Mdluli, who represents the non-bank financial services sector. Over to you, Ms. Kunene.
Good morning. Thank you, Program Director. As I've been introduced, I'm Nomfanelo Kunene Tobela. This morning, we are very happy to be here to speak about a topic that is problematic but also interesting. The session today is on ultimate beneficial ownership, but it is more working, we'll be discussing the vulnerabilities and opportunities in implementing ultimate beneficial ownership to mitigate illicit financial flows in Eswatini. May I start by introducing the panel? I'll start with myself as the moderator. I've introduced my name, but I work for the Central Bank as a Deputy Director, Financial Surveillance. I am a lawyer with a degree, LLB, and an LLM in Transnational Criminal Justice. It is a Master's on Financial Crimes that specializes in transitional justice. I am a certified anti-money laundering specialist with ACAMS, and I am a trained assessor by Esamulag, having participated in the assessment of Lesotho. I will introduce the panel, starting with the Registrar of Companies. Mr. Msebe Malinga is the Registrar of Companies under the Ministry of Commerce and Trade. He is also a lawyer holding an LLB degree. He is a trained assessor and has been trained on ultimate beneficial ownership as the expert in that field. From the supervisors, from the Financial Services Regulatory Authority is Ms. Hlopsile Langwenya, who is the Manager, Money Laundering Control. She is also a certified anti-money laundering specialist, having been trained also on having a certificate in advanced money laundering, a certificate of economic crime schemes, certificate in fraud risk management, and certificate in financial crime investigation. Mr. Tabile Mamba works for the Central Bank as an anti-money laundering analyst. She holds an honors degree in BCom Economics and Risk Management. She's a certified financial inclusion expert and is an associate member of the Association of Certified Anti-Money Laundering Specialists. She is also a trained assessor and has been trained on various trainings, including foundations on anti-money laundering and anti-money laundering risk management. We have the pleasure of being joined by the industry in this panel. It's normally the supervisors against the industry, but now it is the supervisors with the industry speaking on a common challenge. We have from the Bankers Association, Mr. Pindamandla Twala, who is the head of compliance at Standard Bank Eswatini. Mr. Mandla Twala is a compliance practitioner with South African Association, and he has been trained on Senior Management Development Program, Diploma in Public Finance and Accounting, a BCom degree in Accounting, a postgraduate diploma in Compliance Management, and a postgraduate diploma in Risk Management. Pindamandla Twala is a former colleague. He once worked at the Central Bank with us under the Financial Surveillance Division. We have also been joined by a representative of the non-banks, Mr. Smanga. Mr. Smanga Mdluli. He currently works with Alwani Capital Partners, and he currently works with Umelusi Fund Managers as the head of investments. He has worked as a non-bank financial services regulator at the then Registrar of Insurance and Retirement Funds as a financial analyst. He then later became a senior financial analyst under the Capital Markets Department at FSRA, and then he moved to the industry from being a regulator to an industry in the insurance sector, in long-term and short-term and health insurance, then moved on to asset management, where he was with Alwani Capital Partners to the current position that he holds. You can already see that I have wealth of experience and I have experts before you. I believe we are going to be giving you an interesting session this morning. Our session is going to start with a brief presentation. To introduce the next slide, we are going to just watch a video. This video is based on the Panama Papers. 7 years ago, we had the Panama Papers leaked, and it exposed a lot of money laundering happening, where funds were being laundered on behalf of politicians and third parties. So with this video, we are just trying to show you how to hide $1 billion in 5 easy steps. But don't take any lessons to implement. Just take an understanding. This video is going to give you an understanding of the concepts we've been discussing yesterday, and then what we'll be discussing this morning. May we have the video played? Thank you. There you are. You've laundered 2 billion in 5 easy steps. I'm sure you are familiar with some of the things you've seen there. Yesterday, Mr. Charles talked about British Virgin Islands. That's where the companies were incorporated. How do you launder funds? You need a bank, you need a friend, you need a lawyer. So the funds will not be kept in your name, they'll be kept in the name of the bank. Ms. Bapegile this morning says we need to get to the ultimate person owning the funds. So in those companies who ultimately own the funds, we saw at the end of the presentation the politician that was behind these funds, and the beneficiary was the daughter. So moving on to today's presentation, we will start with the definition of ultimate beneficial ownership. Please go to the previous slide. Now, what is the ultimate beneficial owner? There are different elements of the definition. So the ultimate beneficial owner is the natural person with the flesh and blood who will ultimately own or control a company. So if you have a company owned by another company and another company, we ultimately have to go through all those layers. Yesterday, the MC said we need to pierce the corporate veil. So you go through to all those layers until you find the person who naturally owns, the natural person who will own those companies. And in this case, in the case of the video, we want to know the person on whose behalf a transaction is being conducted. Even if you have a person going to open a bank account on behalf of a third party, we need to know that third party. And in the case of a company, we need to find a person who exercises effective control over a legal person. You may find that you have a hidden shareholder somewhere, and you are trying to understand that company. So you have to understand who makes decisions in that company. Sometimes you have listed public companies where you find that there are many subscribers to that company, to the shares. It's ultimately difficult to find who owns, because you probably find 20, 50 shareholders. There you will not go to that step, but you'll say who effectively controls the affairs of this company, because that's the person who takes decisions over that company. The person who exercises controls, and it's an ultimate beneficial owner, is the person who will also benefit from an asset or transactions directly or indirectly. The ultimate beneficial owner sometimes may not be the owner of the funds or the assets, but they will be ultimately beneficiaries. For example, in a trust, the trust funds, there's a founder or settler who funds the trust, they are trustees, but the people who will ultimately benefit are the beneficiaries. They are not the owners of the assets, because they were not the founders and the settlers. Sometimes, like I said, it will be difficult to identify the owner, so you will then identify the management, the people who control the voting rights. Please go on to the next slide. So what's the basis for identifying the ultimate beneficial owner in anti-money laundering and counter-financing of terrorism perspective? We know that money laundering happens through the financial system, and the customers are legal entities or trust companies. So there's an obligation on countries to identify beneficial ownership and ensure transparency in transactions. So we have countries, the recommendations, I'll just read them as they are, is that the countries should assess the risk of misuse of legal persons for money laundering and terrorist financing and take measures to prevent their misuse. So the understanding is that legal entities, as incorporated in Eswatini under the Registrar of Companies, will be abused one way or another to launder funds. So people will open companies as shell companies. They will not operate. They just want a company that will own an account. So the obligation is on Eswatini now to understand that on the companies that are in his portfolio or in his databases, which ones are being abused for money laundering, and in which sector are they likely to be abused for money laundering. And the obligation is that the country should then ensure that there is adequate, accurate, and up-to-date information on beneficial ownership and control of legal persons that can be obtained or accessed rapidly and efficiently by competent authorities, either through the registrar or alternative mechanisms. So a country must make sure that all these layers, we know who is the beneficial owner, who is controlling that company, and the law enforcement authorities can obtain that information when they have to. And then the country should permit legal persons, should not permit legal persons to issue new bearer shares or bearer share warrants. So bearer shares, I learned of this term bearer from checks. So there were bearer checks where whoever holds the check is the owner of the check. There was no name written on the check to say this check belongs to Nomfanelo. No, Nomfanelo could give it to someone else and negotiate it to someone else. Whoever holds that share was bearer. So this recommendation says the countries should not permit bearer shares because whoever holds a share certificate with no name is bearer. And that will then prevent us from knowing who is the ultimate beneficial owner because it depends on who holds that certificate at a point in time. So the requirement now is that we should prevent the issue of new bearer shares and the misuse of any existing bearer shares and bearer share warrants. Countries should then take effective measures to ensure that nominee shareholders and directors should not be misused for money laundering or terrorist financing in a company. You know, as a shareholder, you can nominate someone to go and represent you in the affairs of the company, and those nominee shareholders should be known and they should not be abused to be acting on behalf of the main shareholder. So countries should then consider facilitating access to beneficial ownership and control information by financial institutions and DNFBPs. So the registrar then should give access to financial institutions. There should not be any secrecy on who owns a legal entity, especially for financial institutions, because financial institutions should understand who's the beneficial owner of a legal entity when they perform transactions or facilitate transactions on behalf of those companies. So you can see that I'm talking about legal entities in this recommendation 24. There's then a complementing recommendation 25 that talks about legal arrangements for legal arrangements. Legal arrangements in this perspective are trust companies. We know that there are trusts in the country that are established by lawyers. So recommendation 25 says that the countries should take measures to prevent the misuse of legal arrangements for money laundering and terrorist financing, because legal arrangements are also used to hold assets. And in the ownership of a trust, there are different people who stand to benefit. You find someone opening a trust for the benefit of their children. So the children don't know anything about the funds, but they stand to benefit. And the funder is probably their parent. Where the money came from, they don't know. The trustees could also be third parties that are holding these assets and that are managing these assets. So in that case, the abuse can be anywhere. You then have to identify the trust founder, the trustees, and the beneficiaries themselves. The next recommendation is that in particular, countries should ensure that there is adequate, accurate, timely information on express trusts, including the information of the settlor, trustee, and beneficiaries that can be obtained or accessed in a timely fashion by competent authorities. And then countries should consider measures to facilitate access to beneficial ownerships and control information by financial institutions and DNFBPs. You see that here they are saying that information should be accessed timely by competent authorities. So competent authorities are law enforcement authorities. In the case of Eswatini, I said trusts are established by lawyers. So it means if you own a trust, your trust deed is with you and information is with the lawyer. I don't know how many lawyers are there in Eswatini, and I don't know how many lawyers are opening trusts. But if you wanted to find information timely and get access on trust information in Eswatini, you would have a challenge. That challenge has been identified in our mutual evaluation report. That challenge, financial institutions are living with it, but we don't yet have a regulator or maybe a designated entity that is going to be looking after trusts. We know that we have a registrar of trust deeds in the country, but registrar of deeds, but the registrar of deeds does not have jurisdiction over trusts. The registrar of deeds will only have jurisdiction over trusts if those trusts have acquired property, because they would then be registered through the trustees. So if the trust is opened and it doesn't acquire property, we do not know where it is. And there has been a case that has been decided to say the Registrar of Deeds does not have jurisdictions over any other trust. We then have that lacuna in our legal framework, and that is why we don't have an expert on trusts. However, I will just request the financial sector to share experience on that, on how they then identify ultimate beneficial ownership later on. Having set the foundation to say we need to implement these measures, I will just ask the panel on how these measures are being implemented in the country, and any challenges that we have, vulnerabilities, and their experiences. Starting with the registrar, Babem Sebe. The first obligation is that we should understand the risks we should understand the risks of legal entities. Do you perhaps understand, know, and have an understanding of these risks? Can you share around that?
Thank you, Nomfanelo, and good morning, everyone. Must I stand? I'm okay here. Good. Okay. Okay. You know, misuse of legal entities for money laundering and finance of terrorism can pose a number of risks in a jurisdiction. The first one could be financial instability, in that companies or other legal entities are able to move large amounts of funds or money around the world, which can destabilize financial markets and can also cause a problem for law enforcement agencies, in that they cannot trace the source of funds. The other issue is corruption. I think a couple of speakers yesterday did touch on the topic of corruption. And in the country's context, Eswatini, companies can be used to bribe government officials and persons who are in position of power to make decisions in favor of those companies when it comes to tenders. I think Charles yesterday also mentioned on the issue of invoicing, whereby you find that, you know, invoices have been escalated to our dear government, and such large amounts are then paid to those companies. The other issue is crime, whereby companies are used for drug trafficking, arms smuggling, and human trafficking. I remember between the years 2018 and 2020, we had an increase in the number of registered companies. And I thought to myself, could it be that we have introduced online services? But I noted that it was a particular community that was registering these companies. And I was like, okay, what's happening now? And the only explanation I got was that we are registering companies for convenient purposes. You find that these communities, they have a 2x2 space, and there's 10 of them in that space, and they are saying they're doing business. But we noted that it was only for a convenient stay in the country, and that's, interpreted to what? To human trafficking. And of course, the other issue is terrorism. You know, companies or legal entities can be used to, you know, source goods and sell those goods to finance terrorism. And the other issue now is, like Nomfanelo had mentioned, there seems to be a creation of a veil of secrecy on the ownership and the ownership of assets in the company when companies are incorporated or legal persons are registered, because now you won't find, you'll have a problem if there's that secrecy veil. You will have a problem in identifying who the owner is and who the persons behind those operations and organizations are. And also creation of multiple layers of these entities. I think we've talked on the complexity of these companies, whereby it is very difficult to actually trace the warm body when there's a complexity in the structure of those companies. And maybe the last one to mention, the issue of use of legal persons, legitimate companies being used for illegal or illegitimate services, whereby a legitimate company can now be used for illicit services. I think sometime in the week we saw in the newspaper there was a truck that was stopped somewhere in the foreign country, and it had some goods. And I tell you, it was just not a random truck. You know, it was an asset of a company. That's the truck, and probably a very reputable company. I think we've also witnessed that in the country during COVID, where in our borders there were trucks that were stopped because they were carrying our beautiful product from somewhere in Hoho. So of course, legitimate companies can be used for illegitimate purposes. Thank you.
Oh, interesting information on the risks. Fortunately, I think Mr. Msabe has a lot of risks that he can share. And fortunately, we have a module in our national risk assessment on the abuse of legal entities. We did not share it yesterday with Calvin because it was going to be part of this presentation. So you can read more about it when you get a copy of the national risk assessment. And we can already see that he's citing cases closer to home, he's citing examples. So now the question to you, Registrar, is that we can see how these legal entities under your custody are being abused. Are you collecting any ultimate beneficial ownership information? And if you are, to what level?
Thank you, Nomfanelo. Unfortunately, Eswatini is still evolving in the legal framework pertaining to beneficial ownership. Our Swaziland Companies Act number 8 of 2009 does not provide for the collection or documentation of beneficial ownership. It also does not provide for a registry or register of beneficial ownership. So currently we rely on our Swaziland Companies Act number 8 of 2009, section 97, talks to the issue of who the members are, the members of a company are, and the register for members as well. We also then collect basic information on the company itself, which is the certificate of incorporation, memorandum and articles of association, share certificates, share transfers, and for foreign companies, certificates of incorporation and registration, and also information on the company documentation itself. And now for the members of the company, we collect, your basic information, which is the names, full names and surnames, postal addresses, location, residential address, shares and share registers. So that's the information we collect currently in the country. And we believe it works for us, but does not qualify what then we define as a beneficial owner. Because at the end of the day, with the complexity of these companies, you then need to get to the warm body who ultimately enjoys those benefits of the company. Thank you.
Okay, thank you, Registrar. Well, it's unfortunate that he confirms that we do not get information on the ultimate beneficial ownership, but we get information on the members. I believe those are the directors and the first layer of shareholders. Okay, registrar. The requirement is that this information should be accurate and up to date. At least do we maintain as a country that this information is always up to date? I believe we do. I'm now worried about the financial sector. Please guide us, registrar.
Yeah. It's a very difficult one to answer because one, the responsibility lies first with the person who's reporting, so which means the companies have an obligation to submit one, accurate, adequate, and timeless information. Secondly, the office itself should then provide accurate, adequate, and timeless information. But then we have controls in place, and we're using our legal authority, of course, which is the Companies Act. Section 151 then requires companies to say at the financial year end of those companies, they're supposed to submit company information. They're supposed to also submit company directors at the time, shareholders, and all the full particulars of the shareholders, including the registered office of those companies. Section 177 then talks to if there's any changes that have been effected in those companies are supposed to then submit to the registrar within 21 days any changes, resolutions, appointments, resignations, anything that has happened in the company should be submitted within 21 days. Then you ask me, does that happen? That's the big question. Does that happen? Yes and no.
Yes.
Like I had said, companies are expected to submit that information within 21 days. And we have also sanctions on that for late submission. So yes, we do have such information. Section 197 specifically talks to the appointment of directors. In that, companies are expected that after a director has been appointed, removed, resigned, that information should also be submitted with the office of the registrar within 21 days. And we have that information. So we can say we do have somehow accurate information, though with those challenges, of course. So we do have controls in place to ensure that that information is submitted accurately, timelessly, and adequately.
And the note, registrar, I'm now thinking from your identification of risks, you are saying that you identified companies being opened for convenience. Are those companies compliant? Because if they are for convenience, in my mind, I'm thinking shell companies. It means they are just companies opened to sit on the shelf to give me status. Are they compliant?
Yes, they are compliant. Remember, I said those companies could be registered for a convenient purpose. So if the brother from another mother comes to Eswatini for a convenience day, obviously they'll be required to have with them valid residential permits. So those permits are attached to those companies. So if the company is non-compliant, therefore they cannot have valid permits. But then, of course, we do have those companies, special companies, like your referred shell companies, whereby they're solely used for loyum shika. And then once it's done, then they're parked there. So yeah, we could have those types of companies. But then again, those companies, they are kept up to date.
The fact that you say you have sanctions. I know the financial sector, when it says sanctions, they think 5 million. I also think 5 million. Then obviously director will say, no, you're being harsh. Sanctions, how much sanctions do you have?
Yeah, that's another challenge. Because those sanctions are just not dissuasive. They're just there, as a cap, but otherwise they're just not effective. Honestly, they're not. For late filings and for non-disclosure is only 280. Only, and it's just nothing. So they're just not dissuasive. It's just a control, not a tool to actually be effective in any way.
Registrar, we must borrow you our powers. You need the 5 million, not 200 registrar. Registrar 200 is pizza. Okay, now registrar, we have one last obligation, bearer shares. Tell us about bearer shares. How do you manage that? Countries should not permit them.
I think, finally, you answered that one in your presentation, of course. And in Eswatini, we don't recognize those. I think even in the instruments that we're trying to prepare, we've touched on that, the issue of bearer shares.
Okay. So bearer shares were never allowed in Eswatini. And nominee shareholders, do you manage those?
That's another very difficult question to ask, Nomfanelo, putting me on the spot. Because honestly, you can never tell and even trace the nomination of a shareholder or a nominee shareholder because there's just non-disclosure on that. One would nominate someone and you never have a trace, whereas I think in the regulations 56 and 57, there's mention of nomination of nominee shareholders, in that there has to be a board meeting, board resolution, where the appointment of a nominee shareholder is approved by the board and endorsed by secretary of the board, and you would have those records. But the question is, do we have those records in Eswatini? I'm yet to see that one.
Registrar. It seems you still have a mammoth task, but I'm hopeful you are preparing a revision of your law bill. Okay. But now I'm concerned, aren't you? So, financial institutions should implement ultimate beneficial ownership requirements, have access. But I know institutions will always comply to comply. But I know that ours are effective in the case of Eswatini. So, regulators, your institutions should comply. Registrar says he doesn't collect the information. I think we're caught between a rock and a hard surface. Regulators want compliance. Institutions don't have the information. Registrar says, I don't collect that information. Now, coming to the regulators, it says countries should, the recommendation says countries should consider facilitating access to financial institutions and entities when carrying out their obligations. What guidance have you given them? Because we have a gap, but we should close it, and we must be compliant. What is the expectations now on financial institutions in identifying beneficial ownership? Please explain to us any guidance you've given to them. I'll start with FSRA. I won't start home.
Thank you, Nomfanelo, and good morning to everyone. Yes, we have a big challenge when it comes to ultimate beneficial ownership. Maybe I may just start by saying that it's not only financial institutions who have the challenge when it comes to ultimate beneficial ownership. As supervisors, we also have a responsibility in terms of the recommendations of ensuring that we prevent criminals and their associates from entering the financial sector. So we also have an obligation in terms of collecting ultimate beneficial ownership information, and we also get stuck when we come to Mr. Msebe and he says, this is all I have. So then we work with what we get from him and other jurisdictions. We do have challenges though, because the standards are not the same. Other countries will keep more information and other countries will keep more. To then assist our entities, because we understand the challenge, we have issued guidelines. In 2016, we issued a guideline, the Anti-Money Laundering and Financing of Terrorism Guideline, where we first guided entities in terms of defining who an ultimate beneficial owner is. We also guided them in terms of how they then identify and verify ultimate beneficial ownership. We've guided them in terms of using the documentation from Mr. Msebe, so your your company formation documents. That is your starting point in terms of identifying and verifying ultimate beneficial owners. And we've said where you cannot trace a natural person or where you cannot find the warm body who ultimately owns that company, we have said that you then need to identify the people who exercise effective control over that company. And then for legal arrangements, we've said if you find that you're now dealing with, they expect you to also identify and verify who the ultimate beneficial owners are. So you need to identify the settlers, the founders, and also the beneficiaries. And once you've identified them, you are then expected to carry out customer due diligence measures on all of those people. Even for partnerships, we've also given guidance that you need to ensure that you identify those who exercise effective control over the obligation. This is what is expected, and practically on the ground, this is what we expected. We also share the challenges and share experiences, and then recommend as to how we can actually better implement the requirement. I'll leave it to the central bank to add if there's anything.
Thank you, FSRA. From the central bank's perspective, we do support the legislation through our AML CFT risk-based approach guideline, where we speak to ultimate beneficial owner requirements. We have a section dedicated to UBO to guide the banks and other financial institutions on how they can find the flesh and blood at the being concealed rather through the face of a company. So we have prescribed that financial institutions should determine the person who directly or indirectly owns 25% of shares or voting rights, or someone, or rather the individual, who has a significant controlling interest within the company, in the sense that they can do the nominations of the shareholders, or they also have a say on who can be removed as a shareholder. But also we do acknowledge that we are under the risk-based regime, and we do allow institutions to conduct a... Thank you.
Okay, I've picked big terms, the high-risk jurisdiction, enhanced thresholds. Let's start with the threshold. You've just introduced a threshold, so please just explain how this threshold operates. What's the threshold?
All right, thank you for the question. So with the threshold, we did apply a methodology in assigning it. So we looked through different companies in the country we sampled, and then we looked at the shareholding, we looked at the Form Cs and the Form Js, and we identified significantly in the country that which set percentage is mostly acquired by individuals. So we then assigned the 25%. We didn't just fish it out, for lack of a better word.
As we own companies, we are being analyzed and assessed, and okay. Thank you. So there's a lacuna from the registrar, but the regulators are giving us guidance, are giving financial institution guidance and setting thresholds. Based on the international standards, the FATF of recommendations will then say, when you identify ultimate beneficial ownership, you can't basically identify all the shareholders because they have different voting rights. So the standard then says, where there are many different shareholders, identify at minimum those that own 25% or more, because 25% or more shares, because they might influence the decision making. So if you own 1% in Yana, you should be taking. And then we learned of high risk jurisdictions.
Yeah, thanks, Nomfanelo. I'm not sure where to start. We've had the submissions from the Register of Companies and from the Central Bank. I think we are glad that the Director of EFIU, Director of Financial Surveillance, Director of Financial Regulations is here, and they've had the fines that are issued by the companies, the Registry of Companies, due to non-compliance to information related to companies. So they will lower the fines on their end. As banks, implementation of the UBO flighted, we need to identify the home board that are owned by Eswatini. But now when it comes to multinationals, it then becomes difficult. Because Charles did show us a picture yesterday, I think it was at Ilova or something, where there were different structures, and you have to go to the ultimate beneficiary owner, which then makes it difficult. The biggest challenge that we are facing, it is to identify the home body. But there are measures that have been put in place in terms of how then do we close that gap. Some companies are willing to share that information, and some companies are not willing to share that information, and they have every right. If we do recall, each country has got different data protection acts which control their personal information, and since we don't have any agreements in place as Eswatini with those countries, they reserve the right to share that information. I'll make an example. The Americans, they don't like sharing their information, so we do have a challenge with those companies. But what we normally do when we've got what we call complex structures in terms of identifying information, this information, we then go to the extent of identifying the controllers as per the information that is submitted to the Register of Companies. That means now we will then, as the UBOs, we will then KYC the directors of that company together with senior management of that particular company. And that is the approach we've also applied with correspondent banks when we are sharing information when they want to KYC us as banks. The issue that is being mentioned of 25% jurisdictions, sometimes it's not easy to identify. It's not all the time where you have somebody owning 25% in the company. In most cases, it's lower than that. And that is when, in most cases, you'll then KYC request information for the directors and senior management. But we do also apply what is called a risk-based sort of a methodology in terms of UBO, whereby you are given the 10%, the 25%. So you will apply the 25% to low and medium risk clients, and then where it comes to high risk clients, depending on your credit, on your customer risk assessment methodology, you will then go to as far as 10%. If there are shareholders that own 10%, you will then have to then...
For me, because the banks have actually explained everything that I would say. We do exactly what the banks have just highlighted. It's actually maybe slightly more challenging for us, given the fact that some of the mitigants that have been put in place, maybe that we're going to talk to later, such as the creation of the link. We, as non-bank financial sector, don't have the direct link that banks have to the Home Affairs and Register of Companies. I'll use your phrase, which is, we comply just to comply, which is unfortunate because, you know, you're just checking the box, collecting KYC, but the issue really comes in the verification part of it. So the questions will be asked, who the directors are, who the ultimate shareholders are, but we're unable to verify that information. That's the biggest challenge there.
Okay. I've just heard an introduction of a link. Registrar, what do you want to tell us about the link before I can interrogate the...
Thank you, Nofanelo. I think in 2018, we developed an online verification platform for company directors and shareholders and the company itself. This platform was solely meant for our financial institutions, but the whole intention was the ease of doing business. To say we know we share the same clients with our financial institutions, documents. But the sole purpose was for that. So we do have a link where institutions are able to source information from our database and also verify those contents of the documents that are being submitted to them for verifying if indeed the structures as presented to him are as presented.
An opportunity there. Can everyone see it? What's a registrar? Financial institutions don't have to collect that information. I see an opportunity there in the sense that I heard the regulators saying they also use the same information.
I wish I could charge for that. There isn't any. Say for say, we need to have those agreements, of course. I know almost all the financial institutions, save for one, is directly linked, and we're supposed to have those agreements. But honestly, there's just no barrier to that to say, we cannot issue this service to someone. I mean, everyone or anyone can be able to source or to have access to that platform.
Thank you, Registrar. The requirement is that financial institutions should have access timely. We need those MOUs, I believe. We get those MOUs with you, and then we will get timely access. Law enforcement, let's go and get MOUs with the registrar. We are expected to apply a risk-based approach. The regulators have given the minimum standard of 25%. It is comforting to know that, okay, well, if there is no anyone owning 25%, and if their framework says this customer is high risk, we will identify shareholders up to 10%. That is comforting to know. At least it is helping us to at least comply with the highest standard. I want to maybe appreciate customers for voluntarily complying without the legal basis. I think that is one benefit that we are getting from the customers, voluntary compliance. I think Pinda wants to add.
I don't think they have voluntary offered to comply. We have forced them to comply as the banking sector due to measures that we put in place, like freezing your account. Some have experienced it because we also applied to personal account. So those are the measures that we've put in place. But what we are seeing with implementing the UBO framework is that each bank will have its own experience. We are losing customers while trying to implement it. And if I can speak like now, the business team back in the office, we are also losing customer deposits, which impact our profit. But so we need to apply a standard approach across the industry. And if we can quickly have that country framework, it'll assist. And if that information can be available at the register of companies, it will make our work easier as the banks and non-banks, because then we'll have one primary source of data where we'll source the information. Yeah, if we can have also data agreements with other countries. Thank you.
That's disheartening. I'm sorry, but now I'm caught again because I'm a regulator. We want compliance and we must meet standards. It's at the expense of profits. Registrar, already there's an outcry. There are profits being lost. Any promises? Are you envisaging any mitigation measures for the weaknesses that you currently have?
Yes. We have a companies bill where we not only the whole intention of introducing this bill was ease of doing business, effecting best practices where we simplify processes, and we're introducing a fully electronic business registry. But then we were also very cognizant of the fact that we have an assignment as a country to address the deficiencies that were actually mentioned on our report, and that is the AML issues that we raised. So in our bill, we have tried to be so explicit on addressing those issues. The first one is the issue of beneficial ownership, which has been introduced in the bill. I think it's section 50 of the bill, where we've had a lot of input being made on the BO itself. BO information, BO registries, and the sanctions as well. Now, the proposal is that for non-disclosure by a company on the BO requirements, we have a 1 million sanction. 1 million Malanga sanction.
For not disclosing shareholders?
BO, beneficial ownership.
1 million.
And then for directors of those companies, we have a 500,000 sanction for that. So we are not playing around this time. We want disclosure for that. So from 280 to 1 million. Yeah. And then we have also touched on the issue of barrier shares. We have explicitly said, I think it's section 17 of the bill, no company shall issue a share which is a barrier share. We're just straightforward on that one. And then the issue of shadow directors, section 195, of the bill, we have said the issue of the shadow directors are going to be liable as the directors themselves. So we have also the sanctions there are very nice on that one. So we have tried to mitigate on the issues that have been raised, the concerns that we have from our stakeholders and competent authorities, in that we also want to harmonize our processes in the issue of the sharing of information, the registers themselves now. So the BO registers are also going to be established, and like we are offering those access to such information, there will also be access to that information on the BO registers themselves. Thank you.
Did you hear that? 1 million. Pinda, 1 million to your pocket, 1 million to the registrar. Now profits won't go. Okay. I wish the CG was here. He said he wants electronic and registrar. We are saying automation. I'm now excited. Do you want to tell us a bit about the system you're bringing? Do we need MOUs for that system?
So we are introducing a fully electronic business registry. We won't be getting those big, huge memorandums and articles of association. The Form Js will be electronic. The Form Cs are electronic. Certificates of incorporation, electronic. And also the system that will be, having access to by our stakeholders will also be fully electronic. So you'll be getting adequate timers and accurate information this time around, because of the sanctions that we have in place now for non-disclosure and late submission of those changes to be made in those companies.
So will we need an MOU, or will just be an online access, automatic access?
In our legislation, we have also explicitly mentioned that this information will be shared to our competent authorities and anyone who...
Space where, with all the KYC and the CDD and EDD that has to happen, you should always remember now.
Nominate the right person. Okay, I'm just excited now. I don't even know what to say. I think we have had an interesting discussion from 280 to 1 million fines for non-disclosure. Now we will have dissuasive and deterrent sanctions. I can't even do the difference with my maths, but I know it's 999 something, yeah, 1,000. regulators have given guidance. I'm sure we are going to be seeing harmony on that one, and our financial institutions will not have an impact on their profits. We are doing well with time. Can I open for questions for my panel? Any questions? Do we have any on Slido? It is either they were not clear or they were very excellent. Okay. We have a question. How often is this ultimate beneficial ownership register updated? You can tell us about the current one and the new system. Do you have a set time or as and when changes? Please explain, Registrar.
Currently, I did mention that any changes to be effected if companies make changes that are supposed to be done within 21 days. And if documentation has been submitted with the Office of the Registrar, it's done within 24 hours.
Sorry, Registrar. If there are no changes, do I at least come and update periodically?
Of course, like I said, Section 151 requires that all companies submit their annual reports.
At their financial year
yes.
end.
So that's, if there's any changes, then they're going to be
within 21 days.
Of course, thank you.
Okay. Experience is when you log on the portal. Some directors are still not showing on the portal. How often do the Registrar of Companies update the portal? Okay, that's probably experience with the portal.
Of course, and that is why we have the portal, because we have had experience. Let me share this. We have experience where we issue out our documents, our Form Js and our famous Form Cs, and when we have endorsed those documents, along the way, it's most...
It is, the portal is up to date. It is the document, the portal is up to date. It is the document that is presented before you that is probably outdated. Okay, I think I like the system already. If you don't have an MOU and you need to verify identification information, it is better you do it soon. All right, thank you. I guess we don't have more questions. I'd like to appreciate my panel. Oh, we have microphone. We have a question on the floor.
Thank you, moderator, and good morning, everyone. My one is a question, the other one possibly a solution to what we have, and they are all directed to Babem 7. When we're discussing the issue of EUPO and shell and shelf companies, you touched on Section 151 as one of the enabling provisions that require you to refresh your documents. That's fair and fine. Now, on the issue of accuracy and the TAMIA's submission thereof, and you are saying the shelf companies or shell companies are still there because they are compliant. Now, my question is, how do you verify the requirement of physical address? Because if that process is robust, you will actually have less of few shell companies or shelf companies which are actually linked with whatever business they want to be linked with. And then the second one, we are saying we have limited information on UPO, and as part of an EDD on your side, have you considered actually doing interviews that will actually give you a framework wherein people will disclose under oath? Yes, there are secrecy laws. Yes, there are all those preventative measures. But then, unless something is prescribed by a legislation, if it is not, there's no criminality aspect that arises from there. So maybe interviews could be one avenue that you can possibly explore. Have you ever considered those? Thank you.
I'll start with the second one. We take that. probably it is one of the ways, one way to actually ensure that we get accurate information. The issue of interviews, though we do it, if we note any issue within the documents that I've submitted, we do then engage that particular person who submitted the documents. To the first question on submission of the documents, whether it's done timelessly and the accuracy on the information, you made mention particularly on the office address or residential address of the company. I'd mentioned earlier on that, the onus is on the person who's submitting the documents to provide that information accurately and adequately. If a company gives information on its residential place or business address or office address, it would be difficult for the office of the registrar to walk out of his office to actually then go and show that or verify if indeed that company is situated where it is situated. So the onus, of course, is on the company or the person submitting the documents to give us accurate information. And yes, with what we are trying to, what we're proposing is structuring the office itself in the way the legislation and the system that we're introducing is going to work. We believe that it is going to work for us in terms of getting information that is accurate. And of course, I made mention of the sanctions, that it should be accurate and adequate. And if it's not, then the sanctions will come in effect. Thank you.
Are you saying, thank you, Registrar. Are you saying you'll be conducting inspections in the new bill?
We do, even in the current legislation, we do have provision for inspections, unfortunately. Resources.
Well, resources is a challenge across the industry. Hopefully, you will be getting more resources incrementally, and in our strategy, going to be approved by council. We have capacity building in terms of human resources as a strategic objective. Thank you so much to my panel of experts. I think we presented a comprehensive subject. Are we having a last question? Mm-hmm. Okay. All right. How come companies that have long deregistered are still listed on the portal and new companies are not listed? Okay. I think we're now inspecting the registrar. I think it's not a fair comment. May we have, if you are already on the portal and you are having challenges, may I request that we discuss this one, you discuss this one with the registrar out of the meeting? It will be an unfair comment on the registrar. Maybe, some systems, systems have human elements behind them. It would be, we'll take it as an area for development. You have a comment, Registrar?
First question, how come we have deregistered companies in the portal? Of course, even deregistered companies, we still need to maintain that register of those deregistered companies. So you'll find them in the portal, however, their status will be deregistered. Because we need to maintain those registers as well.
Now, I think the registrar will need to train us on understanding the register. Yeah. Okay. I think, wow, interesting. So you will have XY deregistered, active. Now I'm eager to see the system. Okay. I've been saying goodbye all this time. Another one. Okay.
Good morning, everyone. I just have a question for the Register of Companies regarding we've seen in the banking sector a lot of companies that are non-Swazi coming in, registering via the lawyers, and then they come in through the bank to want to open accounts. I just want to understand how involved is the Register of Companies, because when we then now try to get the ultimate beneficiary owners, we always struggle.
Okay, so the question is saying, does the registrar recognize foreign companies before they operate legally in the country?
Thank you very much for that question. I'll answer it in two ways. One, we have companies registered in Eswatini whereby all directors and shareholders are foreign nationals. Okay, that's one. And in our bill, we have made a director residency requirement that at least one director should be resident in the country. Okay, for purposes of AML and CFT, of course. And for foreign companies, we have a register and a list and information on foreign companies. So when foreign companies come into Eswatini to do business or to set up a branch or office in the country, we require them to submit documents of their company documents from the country of origin, certified from the country of origin. We capture them and then we issue out a certificate of registration now. So we have information on them, we have data on them as well. Thank you.
Is that in the current dispensation?
Yes.
Oh, interesting. So we have a certificate of incorporation and a certificate of registration. Okay, and they are also listed on the portal. Okay, new lesson for me today. Thank you, Registrar, and thank you for the question. Now I'm going to look around for more questions. Okay, I'm also mindful of time for the next panel, and I'm standing in between you and your break. Okay, going once, go on. Thank you so much. You've been a good audience, and thank you so much to my panelists for the new information and for the current positions. Thank you.
Thank you, Ms. Kunene. Thank you very much, Ms. Kunene, and your learned panel. Thank you for sharing such useful information in terms of how we identify ultimate beneficial owners. And thank you very much to our registrar of companies in terms of sharing the good news of the system that is coming in and the bill, the new legislation that is coming in that will allow us or make us compliant with the recommendations in terms of identifying ultimate beneficial owners and in terms of implementing or being effective by imposing those high sanctions that are coming. I am hopeful that when the new parliament comes in, the omnibus law and the bill are going to be among the first pieces of law that are going to go through parliament so that we avoid being grey-listed as a country. At this point, may I kindly invite everyone to a break. We've been allocated 30 minutes for the break. It's now 10:30. Can we be back at 11 for the last session of the day? Thank you.
as well as Ms. Pepile Dlamini works with the Central Bank of Eswatini, represents the regulators, and has worked with financial sector regulation for over 7 years. She has developed a wealth of expertise in AML CFT regulation and supervision, as well as extensive experience as a trained AML CFT professional assessor. Currently, she serves as a lead specialist in financial integrity at the Central Bank of Eswatini. She has made various contributions in virtual as a member of enterprise risk management. Ms. Mamba has also has over 12 years experience as a compliance practitioner. Mr. Mdluli currently serves as a senior compliance officer at the Eswatini Financial Intelligence Unit, where he has been instrumental in upholding regulatory compliance in the financial sector for the past 6 years. He holds a Bachelor of Arts in Law, LLB degree, and postgraduate certificate in compliance management. He is an admitted attorney of the High Court and has underwent training as a FATF standards assessor, and has further underwent extensive training in the supervision of designated non-financial businesses and professionals, beneficial ownership, and non-profit organizations. Ladies and gentlemen, please join me in welcoming our panelists today by a round of applause. So, as earlier mentioned, this panel today, we will be discussing virtual assets and their impact in financial crime, on financial crime. Then we'll be looking at the strategies by law enforcement, regulators, as well as prosecution in the country. Maybe to be on the same page, let's start by introducing virtual assets. For the purposes of this panel discussion, as well as the Indaba, we will be adopting the FATF recommendation of virtual assets, or rather the FATF definition of virtual assets. The FATF defines virtual assets as digital representation of value that can be traded and or used for payments or investments. This definition, however, excludes the digital representation. But for people like me, who started the conversation or the discussion of us early, when we talk about virtual assets, we are talking about your cryptocurrencies, we're talking about your crypto assets, we're talking about your virtual money, depending on when you joined the conversation. But the most adopted word now that describes your cryptocurrencies and other forms of digital money that is privately issued has been virtual assets. So for this panel, we will be adopting the word virtual assets, but if you know cryptocurrencies, if you know crypto assets, we are with you. We are still talking about the same thing. Thank you. So as a background, what I have learned is that virtual assets actually date way back before 2009, but it became more common in 2009 with the introduction of Bitcoin. And the value of virtual assets with the introduction of Bitcoin gained momentum and has skyrocketed. These virtual assets currently, when we started in 2009, it was only Bitcoin that was known, but to date, there are over 26,000 different virtual assets, and their total worth as measured by market capitalization is over 1.2 trillion US dollars. And this is down from an all-time high that the market reached in November 2021, which was about 3 trillion US dollars. So this is to say, virtual assets have actually joined mainstream financial services. And at the beginning, it was more of referenced as a bubble that is going to burst at any time. But it's been what? 2023 minus 2009? 10 years. It's been over 10 years. It is still happening. A lot of people are still engaging. And what we have seen is that
on all transactions that go through our financial sector. We have, over the years, seen or identified virtual asset transactions that are going through our authorized dealers or accountable institutions in the AML context. How do we do this, or how did we manage to see the transactions? We have a cross-border reporting system that we are using as the bank to monitor all outflows and inflows into the country, into which we were then able to identify the virtual assets that our eMaSwati are trading in. What we are seeing is that we locally do not have a virtual asset service provider. However, our eMaSwati are actually trading or investing in two virtual assets that are based in South Africa. Mainly, we have the altcoin and the Luna. Who is trading? We have observed that mainly natural persons are the ones that are trading compared to legal persons. And if I may compare, it's about 98% in terms of value and transactions that comes from natural persons. The magnitude. If you look at the time when we started monitoring, specifically, we were specific on this one, we're monitoring virtual assets. This is a study that started in 2019. And if you look at the figures, they are increasing. That indicates an appetite by eMaSwati in actually investing in virtual assets. For a start, let me also just mention that the first transaction that we saw was in 2016. However, our monitoring started in 2019, where we saw about 2.4 million in value from natural persons. This does not include all authorized dealers. I just went into 2 authorized dealers that I just checked in. And then for the 2.4, it grew in 2020. The increase was around 300%. And then in 2020 to 2021, the increase was around 100%. From 2021 to 2022, even though there is increase, but it was at a lower rate compared to the previous years. One would want to indicate that, yes, eMaSwati are trading, and they are using the financial sector. And there is one worry that we have as the central bank. We are seeing a lot of money going out, and it is minimal, say less than 10% of money coming back. So eMaSwati are investing in virtual assets, but the money is not coming back. This is now giving a rise to issues of eMaSwati, or the money that belongs to eMaSwati, being externalized. That is an issue that the central bank is currently dealing with. Thank you.
Thank you so much, Pepile. That was detailed analysis. I think what I got is that eMaSwati are interested, and more eMaSwati are getting interested. But what also Pepile highlighted is that there is no licensed or registered virtual asset service provider in the country. So what does that mean? And what is the risk to the consumers? But we will get to that question later. May I ask colleagues from the EFIU, Pepile has highlighted that through the financial system, we are able to see these transactions that relate to virtual asset service providers. So from the AFIU, has any suspicious transaction, have any suspicious transactions been reported, and are there any typologies that you can share from your perspective?
Thank you, Telo. Good day, everyone. I'm Bongani Mdluli from AFIU, a central repository for the STR for the purposes of analysis and dissemination. Yes, we are seeing a rise in terms of Eswatini who seems to participate in virtual assets, and there are some STRs which are related to virtual assets trade. What we are seeing as a typology is that since we don't have a registered or a licensed VASP here in this country, such an individual poses fronts for entities in SA, that's VASP, that's a virtual assets service provider sitting in SA, whereby they collect money from the public and for the purposes of investing in South Africa. They collect, that's illegal deposits taken from the public, and or else the public, they invest directly to those service providers in SA. What we see is that it opens a window for fraud. Many people have been defrauded. As Pepe has alluded, that a lot of this cash, this outflow of funds, it not seems to be coming back. The money is going out, but the returns, we're not seeing them coming back to the investors. So it opens an opportunity for fraud, an opportunity for Ponzi scheme, where people are being defrauded of their monies under the pretext that they are being invested in virtual assets. Those STR relates to virtual assets. It's where some people who are funds for investment and thus are collecting their monies from the public in terms of illegal deposit taking, and also whereby the public are being subjected to being defrauded. Yeah, thank you.
Thank you so much. I think EFIU has just raised some of the risks, the challenges, and the criminality that is happening through virtual assets. Also, when Pepile raised the issue of money flowing out and money not coming back in, I want to believe that there is a chance that someone was defrauded, someone was scammed, that is why money is not coming in. And from the police, has anything been reported? Has any criminality been reported from your end? And can you share maybe a summary of the reported cases as well as trends that you see in those cases?
Yeah, as Ella introduced, I'm from the Royal Eswatini Police Service as a financial investigator. What we have seen as law enforcement is that we don't get any official reports from the public or from other stakeholders in relation to virtual assets and money laundering or any fraud cases which are in relation to virtual assets. What we see is that most people, they get defrauded in online scams. That is whereby they go in Facebook, they see a post which will say that there is a 300% return on a cryptocurrency exchange, and they fall for that, and they invest their monies into scammers, thinking they are investing in cryptocurrency exchanges. So we don't see any actual cryptocurrency or virtual assets being scams. But now there was a time in 2016, as Ms. Nandlamini did mention, whereby the media had a large coverage of Bitcoin millionaires. Most people saw a rise in, there was a rise in Bitcoin prices, and many people became millionaires. And there was also another rise in scams, whereby people would perpetrate that they currently have the next Bitcoin, meaning an alternative coin to like Bitcoin. There was one which was most known. It was called Dust Coin. At that time, people like invested in Dust Coin. It was actually an initial coin offering, meaning it was crowdfunding for a cryptocurrency project. So most people, they invested in that Dust Coin, but all to now find out that it was actually another fraud. So they didn't do their due diligence on that coin. They didn't read the white papers. They didn't actually like research more. So it's unfortunate. We haven't received any cases. Thank you.
Thank you so much. Mr. Ngumalo has highlighted that they are seeing some criminality from a law enforcement perspective. And unfortunately, if nothing has been reported to them, there is nothing that they can investigate. There needs to be a formal, a formal case opening so that they can be able to assist. So, Mr. Makakula, from a prosecution perspective, can you share, in as much as Mr. Ngumalo has said nothing has been reported to them, I would then not expect that you have prosecuted anything. But can you share from your perspective, what are you able to see and what are the insights from what you see?
Yes, thank you, moderator. May I confirm that we have not received, a docket arising from an offense relating to virtual assets. But as Mr. Ngumalo has indicated, the reports or some, I can confirm for instance that I have one particular file where the people were defrauded, and what happened is that the person, and we've seen this online, it's quite shocking, will say that he can trade for you, buy cryptocurrencies if you, pay money to him or her. And people are actually doing this. They believe, these scammers, and obviously they will tell you that the higher the investment, the higher the return. And people tend to be tempted, to say you want to get the maximum. It's incredible returns, they'll tell you 10%, 20%, 30% of your return. So if you put in 200,000 Marangani, for instance, you can imagine the return there at 30%. You see? So I've actually personally seen in one of the leading hotels in the country where there was someone from South Africa, they call them seminars, who was conducting a seminar telling the people what I've just said. Come to me, I will trade for you cryptocurrency, and you'll make a killing there. So that is what we have. So we have not really prosecuted or received any case arising from virtual assets. I don't know also, moderator, whether I'll get the opportunity later. I was thinking that it is probably important in a setting of this kind to demystify the cryptocurrencies, because people tend to have the belief that they will have to go through someone in order to trade. You see, when that is not the case, you can yourself individually. It has been confirmed. We do not have VASPs in the country, but that has not stopped people from investing in South African based VASPs. In fact, a large chunk of Southern Africa is investing in crypto exchanges that are based in South Africa. And people are going there individually. You know, you can approach a VASP yourself individually, where you indicate your intention to trade in crypto, and then you will then be assigned a private key and a public key, which is your address, you know, on the blockchain. Then most of the VASPs also allow you to link a bank account to your, you know, crypto address. And in terms of you now trading, it's up to you how much you put in, how much you take out. And it's your discretion also when you get out, because you may decide I've made enough, because the trend is that you buy when the price is low, and you sell when the price is high. So people buy when it's low, and they feel now the price is high enough, they sell. They cash out, because you go back to the same VASP, you cash out your fiat currency from whatever coins you have there and get out of the system. You don't need anyone to intercede for you there. So people should know that these people going around posting on Facebook, WhatsApp, and all this, holding seminars in hotels, are basically con men. They are there to con them, you see. And it's, for them, it's quite a profitable scheme. With respect to the file, I will not mention any names. The so-called investors lost over 3 million. Sadly, some of them are pensioners, you see. And the person is there in South Africa enjoying the proceeds. When inquiry was made by the investors to the gentleman, hey, we've given you our money, where are the returns? The response was that at the time, the former president of the United States, no, sorry, you know, we were investing in America, so now the president there has blocked all repatriations, you know, of funds from the United States, so your money is blocked there and I can't get it back. Con men conning innocent citizens. Let's demystify this. You can invest yourself. You don't need a person to intercede on your behalf. Thank you, moderator.
Hence, anyone support what Mr. Makakula is saying and say, I have invested directly with the VASP. I didn't need anyone to do it on my behalf. It's truly possible. Anywho, stawubona and post. This is yakhala manje. Because you do not want to share. Anyways, thank you so much. Regulators, FSRA and CPE, the police, the prosecution have said that they haven't received anything, any complaints. I just have a little faith in me that people know that there's ombudsman offices with the regulators. They know that financial matters or financial crimes or their financial grievances, that's where they need to be directed. Can you share if you have received anything that is related to virtual assets as a form of complaint through your ombudsman? Maybe we can start with the FSRA, then the CPE.
Thank you, moderator. Good morning, everyone. My name is Lindiwe again. As the FSRA, we haven't received any complaints at the ombudsman so far. However, what we have received, it's registration requirements or licensing requirements. So every now and again, we'll see people coming and asking for registration requirements, and they will say that they have huge monies that have been receiving from the banks, and the banks, they are questioning the sources of funds, or where did they get their monies from, yet they are trading for themselves. So now, to legitimize their businesses, they want to operate in the open. So our response has always been that currently, we don't have a regulatory framework for the type of business that we have ventured into. However, we are working on something as a country, as a whole. But for now, everything is at embryonic stage. So when the requirements or the framework is available, it should be made available to the members of the public. Thank you.
Thank you very much, moderator. As the central bank, we have not received specific complaints on virtual asset misconduct from the public. However, we have conducted a few investigations around Ponzi schemes and pyramid schemes where in the process you then discover that there was a component or a leg of virtual assets trading that was going on. Thank you.
Thank you so much. I'm a bit worried. Or maybe let me just say, so it's one of two things. It's either Eswatini know what they are doing, they are not scammed, and they are happy, they are billionaires, or sifile maflask lagangwan, bamfuba fela ngekhathi. It's amazing when you see the magnitude of the transactions, and when you see all these posts, and when you see all the outcry. Maybe we need to have law enforcers on social media, because from a consumer's perspective, on social media, I see a lot of outcry. Maybe can you share, EFIU, from a high level, why are people not going to the regulators, to the right places to report most of their crime, or most of their outcries? Why are they crying on social media to their cousins? Maybe there is some form of intelligence from your end that you can share to say, why are there no reported cases? Why are there no formal complaints raised with the regulators? Please.
Okay, thank you, Taylor. My assumption is that most of the time, the regulators, in particular the central bank, they sensitize the public that these virtual assets, they are not being regulated. So you trade at your own risk. So they know that this is a product which is not regulated, and the regulators, they don't have any powers whatsoever in terms of their complaints, in terms of addressing their complaints. So they will be reluctant to go there because they know that they've been sensitized they've been cautioned that you invest at your own risk. So once you got scammed while you are trying to invest there, then it becomes your own baby. I assume that's the reason. Maybe someone could have a different answer to what I think. Yeah, thank you.
Please, Mr. Ngomalo.
I also share the same opinion here with my colleague. I don't know how to put it, but what I am seeing is that people have an appetite for quick returns. They want something or some kind of investment now vehicle which offers quick returns. And it's more of like a drug, you would think, because they will jump from this scam and go to another scam and go to another scam, and you keep wondering why continue, but they also don't have a clear answer. They just are addicted to having quick returns. So I think our financial institutions have a job to do and provide some product that offer quick returns so that people don't keep going to these scams. So I think that's the problem. People, they know that they are getting like into scams and they have accepted. Like actually what I've seen most say, like when it comes to the market level or the pyramid schemes, they usually say that meaning they go there knowing the risk that they might get scammed. So I think that's the problem we have. They go there, they are gamblers. Thank you.
Thank you so much, Mr. Ngumel. You know, when I said earlier, emaswati ayati kutendani, ning pixile, I had some no from the audience. Mr. Ngumalo has attested to that. In as much as they do not know what they are doing in terms of virtual assets, they know what they are doing in terms of gambling. All right, thank you so much. So we have seen a lot of reactions, different regulatory actions from different regulators and countries globally. We have seen countries like China, Morocco, they have decided to ban cryptocurrencies, either by criminalizing any interaction with virtual assets or by prohibiting financial institutions from facilitating any virtual assets related transactions. I think from what the CPE said earlier is that for people to participate, they move the money through the existing financial system, through the regulated financial system. So what other countries or what other regulators they have done is prohibit the licensed entities from facilitating that transaction, which is trying to make people not participate by destroying the bridge between the fiat and the virtual assets. And we have seen other countries, other regulators actually saying, we see that people are participating, and the best thing that we can do for our countries is actually to try and regulate. Countries like Botswana, countries like Mauritius, even the European Union has brought in new regulations that are specifically for virtual assets, for the virtual assets industry. And today we are here, I think I've seen a lot of FATF recommendation going on, and most of the recommendations that have come from these international regulatory support bodies, such as the FATF, the IMF, the World Bank, the bank supervision regulatory bodies, what they are saying is that instead of banning the virtual assets like others have done, because people are going to find a way to continue participate and actually risking pushing further the underground operations of virtual assets, regulate them. Subject them to the same level of regulation as the financial institutions. And I think one of the bodies that have come up with recommendations for virtual assets is the FATF. Maybe CPE, at a high level, could you unpack what are the recommendations of the FATF in terms of virtual assets regulation?
Thank you, moderator. If I am to unpack Reg 15 that speaks to new technologies. I think the best way is to start with a definition that is given to virtual assets and virtual asset service providers. According to FATF, a virtual asset is a digital presentation of value that can be digitally traded or transferred or used as an investment. The definition continues to say it does not include virtual assets that are linked to fiat currency, meaning if the central bank would have a central bank digital currency, according to FATF definition, it is not going to be a virtual asset under FATF definition. It also, if I may also borrow another definition of virtual assets from the Financial Services Regulatory Authority, Abu Dhabi, they say a virtual asset is a digital presentation of value that can be traded digitally, and it can work as a function of a medium of exchange, a unit of account, and also a store of value. So from that, you see that a digital currency is not issued by any jurisdiction, but rather the value of a digital or a virtual currency, according to FATF, is a currency that is determined by the market. And then for virtual asset service providers, the guidance that is given by FATF says a virtual asset service provider is a natural person or a legal person whose business is to, one, it gives about 5 properties. One is one that is in a business of exchange of fiat currency to virtual currency. The second one being the exchange of virtual asset to another virtual asset. The third one being the transfer of virtual assets, and transfer also has a definition that means there should be a third party that is acting on behalf of another person. And then it says the fourth one speaks to securities, and then the fifth one speaks to the person that then is a trader under virtual wallets, which is mobile virtual assets. And then once you get that definition, it then states that as a country, we should be aligned to that definition given by FATF. What is then recommendation 15 saying to countries and financial institutions? Reg 15 says countries should conduct risk assessments, MLTF risk assessments for virtual assets to understand the MLTF risk associated with virtual assets. It goes on to say they should then obligate virtual asset service providers to also conduct risk assessments on their MLTF risk exposures. That is the first leg, risk assessment and risk understanding for virtual assets for countries and financial institutions. It goes on, I'll be a high level, right. It goes on to then say they should be licensed or registered. So countries are obligated to license and register virtual assets service providers. It also then touches on beneficial ownership and also touches on the licensing, which is the market entry. You need to ensure that criminals are not owners or traders in the virtual asset space. It goes on beyond that, that then there should be a designated supervisor. They should be subjected to the same supervision as other traditional financial service providers. Once they are supervised, then they should be accountable institutions in the local context, and then they need to then comply with all the requirements as set out under recommendation 9 to recommendation 23, preventative measures. high-level moderator. And then it then goes back to say, then countries should ensure that the fines or the criminalities that are imposed on money laundering, terrorist financing, and the obligations that come on targeted financial institutions should also be applied on virtual assets. Fast forward, it goes to recommendation 37 to 40. It says, Mr. Makakula's international cooperation should also be a part, or virtual asset service providers should also be obligated, or should be, it obligates countries to also have mutual legal assistance or international cooperation around virtual assets for competent authorities to discuss. Then there is this component that is brought in by recommendation 15 of prohibition. I think you've touched on that one. It says then countries have an option to prohibit virtual assets in their countries. But then before you prohibit, it requires you to then conduct a risk assessment. So there should be an understanding of the risk before you prohibit it. And then it also then touches on the issue of residence. So where is a VASP, or where is a VASP, or where should a VASP be registered? Or where is it a resident? It says for natural persons, it is where the person is residing, where the records in the books of that person is available or are held. And then for jurisdictions is where they are, for juristic or legal persons is where they are registered. So I think for the country then, we need to then mirror what we have done with what recommendation 15 is saying at a high level. Thank you.
Thank you so much, Pepile. That was very detailed. I think everyone is all ears and ready to start doing their own assessment in their different fields, because we have got that from the FATF recommendations. There's not just recommendations for the regulators or the authorities in the country, but there's also recommendations for the intermediaries that are intersecting with the virtual assets market. So, FSRA, I know that in 2021, it was discussed in this Indaba that we have conducted a mutual evaluation with Assembleck, and one of the discussions was on virtual assets. From just that and any other information that you can share, how far is the country in achieving or meeting the recommendations of the FATF as highlighted by the CBE?
Thank you, moderator. Subsequent to the NRA, or subsequent to the issuance of recommendation 15, the country in August 2022 issued a legal notice which amended Section 3 of the AML Act to designate virtual service providers as accountable institutions. However, as a means for complying to recommendation 15, we fell short because it covers only 3 virtual asset service providers, which are exchanges, issuers of virtual assets, and services of virtual assets. Yet in the FATF definition, when you talk about VABs, you will talk about virtual asset wallet providers. We'll talk about virtual asset exchanges, which are in our amended law currently. And you'll talk about virtual asset brokering, payments, processing, and also talk about virtual assets management providers, initial coin offering, which is a service that is conducted under the virtual assets exchanges. And also, there is also an element in the definition of FATF that talks to virtual asset investment providers. and validators of miners and administrators. That is to highlight to say, yes, we have done something, but we still have a long way to go because we need to address that gap. And then the supervisors, which is the central bank and also the FSRA, also trying to address the issues that were highlighted in the mutual evaluation. We are busy with the concept paper. And the concept paper, it's aimed to understanding, the general understanding of what are VAPs amongst the regulators. Number two, what are the risks imposed and what are the implications? And we are hoping that when we complete the paper, or the main objective of the paper is to come up with, is to propose a regulatory and a supervisory framework to be used in supervising the virtual assets in the country. And also, as much as it's not in the country, but it's in the region, and the country is also participating in a survey conducted at a SAMLAC level, whereby we are trying to understand the challenges and opportunities, the risks, and also the gaps amongst regulators and amongst countries. And the aim is also the same, because in completion of this paper, the policy paper, is going to inform countries to implement policy and regulatory responses which enhance financial integrity and stability in the SAMLAC region. So far, that's what is happening currently. Thank you.
Thank you so much, Lindiwe. I think the story is the same. There is no registered VASP, there is no licensed VASP. People are participating. Now, from the submission we are getting is that there is even no regulatory framework in Eswatini. But there has been the amendment of the AML CFT Act to say VASP are accountable institutions. So under that amendment, what are the implications for VASPs? We do not have a regulatory framework, but according to the amendment of the AML CFT Act, VASP are accountable institutions. How do they go about with complying, or how do they go about with obliging with the amendment of the AML CFT Act? Can the EFIU assist in that regard?
Thank you, Talo. Yes, virtual assets and VASP have been listed as one of the accountable institutions in terms of the amended Schedule 3. That means that they are expected to implement some controls, some regulatory controls in terms of your KYC, your CDD. So virtual asset service providers will be expected to implement the same controls as other licensed financial institutions. So they will be expected to adhere to that obligation as prescribed by the AML Act, and which means that the FIU, because if there's still no regulator, I think there's still to be a policy decision as to who is going to regulate them. But in the event that there will be no prescribed regulator for them, the FIU have to step in and into that lacuna and regulate the AML aspect of it. Thank you.
Thank you. So if I understand you very well, the ones that have been knocking on the FSRA's door saying, how can we be licensed? Or how do we get to be registered to provide virtual asset services, need to be knocking at the EFIU's door currently?
Yeah, I can answer that one. Yeah, maybe my colleague from FSRA can speak to that one.
Okay. If I may, moderator, I think for that one, our legislation is such that there is actually no, I'll say, lacune on who to regulate in terms of and what to regulate and who is responsible for what according to our ML Act. Our ML Act is specific to say for those sectors that have regulators, they are the ones that have powers to regulate and supervise for ML CFT. But for those that do not, the EFIU is always the one that takes on those until probably the position on who to regulate in terms of the, you know, the five types of virtual assets, then meanwhile, the EFIU should be the one that is taking over. But remember yesterday, one of the presentation, or the presenters did mention that we have a supervisory forum. So if in any case, there is a need for us to collaborate on that one, we can always, our forum is open to actually do that. But currently, there is no one in Eswatini that will say, I am not regulated for AML CFT. Because if not, we have 3 supervisors. If you are not in the banking sector, if you are not in the non-banking, you definitely fall under the FIU. Thank you.
Thank you so much, Pepile. So I think as we were introducing, as we were setting the scene and trying to understand the virtual assets landscape in Eswatini, we highlighted briefly on some of the risks that come with virtual assets and virtual assets service providers. The FSRA has been leading the National Risk Assessment AML CFT. Maybe at a high level, Lindiwe, could you share the risks that were identified for both consumers and overall financial sector and the overall financial sector in relation to virtual assets and virtual asset service providers?
Thank you, Delu. When we did the NRA on virtual assets, as our previous speakers yesterday, they indicated that we're using the World Bank tool. So the World Bank tool gave us the number or the type of entities we're expected to assess. Since we've mentioned that we don't have registered VABs in Eswatini, we were unable to cover all of them. However, because already we are aware that there is an activity on the ground, and we have established that the activity is happening on virtual asset exchanges, which is currently Altcoin and also Luna, we made our analysis or assessments based on that. Maybe one will ask before I go into the risk to say, so now if there are no licensed virtual asset service providers in Eswatini, so how do these people know about Luno and also Altcoin? So currently in Eswatini, amongst us, there are unregulated quasi-brokers or agents that go around marketing the virtual assets business. And what we gathered, we found entities like QZ Asset Managers. Some are called Crypto Lovers Academy, and Vols Market Swaziland, Cryptocurrency Exchange Eswatini, and Swaziland NFT Network. So what do these people do? First of all, they introduce you into the idea of virtual assets. Some to individuals, some they offer trainings on how to train you in doing virtual assets, and also volunteer to help you to deposit or take the money. So that's where we are and how the activity is taking care and how most people know about virtual assets. So when we did the assessment, the National Risk Assessment results relating to virtual assets and virtual assets providers. we noted that Eswatini, when it comes to MLTF risk, the overall exposure is very high, the risk. And then when in terms of threat, it was also very high. In terms of vulnerability, it was also high. And then when you talk about the threats, the threats that were observed from the interviews, and also because here we found ourselves like in a position whereby we don't have the activity, but we need to communicate something to the nation. So normally in the absence of an activity, what you do, you then go and look at typologies. Typologies meaning the activities that have been observed in other countries. So we discovered that the threats that are related to VAPs, they are fraud, like fraud schemes, as Mr. Makakule has mentioned. There's corruption, there's tax evasion, there's drug trafficking. For the purpose of the high-level presentation, I'm not going to go or discuss how there's fraud scams or the threats manifest itself, but this will be discussed in another question as part of the discussions of the panel. However, when it comes to vulnerability, the main vulnerability, first of all, was that as a nation, you don't understand when you don't know what are VAPs and VAS. And then secondly, we don't have a regulatory framework in the country. And in the absence of the regulatory framework, the oversight of VAPs can't happen. Reporting of suspicious transactions, this is why maybe our colleagues from FIU has reported that there are no suspicious transactions. This could be the cause. And also the inability to identify the beneficial owners. There is also lack of expertise in monitoring and prosecution and recovering and seizing of VAPs. And also, what we noted is that by its very nature, VAPs are very anonymous. So transactions like cross-border flows, transnational crimes, render investigations like police investigation to be very impossible because being in Eswatini, having an experience of investigating the conventional crime, now we have VAPs and they're operating and you don't know the extent and you don't know who the service providers and they're anonymous, then investigation becomes a problem. And also, there's also an element that relates to VAPs, which is they are very fast. The transactions are very fast. So with that, it also inhibits the law enforcement from tracing the transactions that related to VAPs. I think that's my high-level presentation that relates to the outcomes of the NRA for now. Thank you.
Thank you so much, Lindewe. I think with the theme of the Indaba being around illicit financial flows, maybe could you also highlight as to how, for the benefit of the audience, how can the virtual assets as well as the virtual asset service providers be used to conduct the illicit crimes?
Okay, thank you, moderator. As you have mentioned that VAPs have been happening in the country for quite a long time. So from the media coverage, you observe that there have been scams. Way back in 2018, there was a M&M. There was also Bitcoin Network and Bitcoin Global. In that scam alone, there were about 300 sources who were operating there, and they lost almost all their monies. And the total monies that were lost for eMaswati alone in that scam, it was 200 million. And the scams were sold by agents, and people were encouraged to join, to put in 15,000, 14,000, 17,000. It varied, but I think it was linked to you were paying in USD. So that's what the media covered during that time. And also, VABs can be used to purchase illicit goods. So interestingly, during the assessment, we discovered that some of our Emaswati who are participating in the two platforms that we've mentioned, the platforms that they participate in, it allows them to access the dark web. So in the dark web, there are two marketplaces that are known, which is the Silk Road and the Agora. And these dark webs, they sell illicit goods such as illegal weapons, drugs. They also offer services for assassinating people. But anyway, that's what happens in the dark web. So they can be used for purchasing illicit goods. And then there's an element of tax evasion. Cryptocurrencies can be used for investment purposes. So in this instance, assuming a person invests in cryptocurrencies and gets the investment return, that money will go into the person's accounts in a fiat, kind of being converted to a fiat, and it won't be taxed by the tax authorities. And then that will have an impact in the revenue stream of the country. And also, virtual assets can be used for cyber crimes. And this takes us back also to the black market, the dark web. So in the dark web, there are criminals that are there for business purposes. There are criminals that are there to hack for a song like $10, and as long as you can access the dark web. And also issues of hacking, especially when there's a ransom attack. Normally the criminals will demand payment to release your kidnapped information in cryptocurrencies. So another method where organized criminals are very happy because it has actually relocated the international organized crime into an online-based or digital kind of crime surveillance. So if you are, our terrorists find us from the fiat money into virtual assets to avoid detection. So far, for the purpose of this discussion, I covered only that, but there are many, like human trafficking, so on and so forth. Thank you.
Thank you so much, Lindiwe. So I think what has come up from the discussion is mainly that Emaswati are participating African virtual asset service provider registration or licensing in other jurisdictions for virtual assets service providers. Do the laws, or rather, are there any instruments that are protecting Emaswati who are participating through international virtual assets providers?
Thank you, moderator. Yes, in the normal course of business, the VASP that is operating there, when it gets if anyone comes to them to open an account, so to speak, they will issue them with the public key, which is the address, and then they will issue them also with the private key that the person will access their wallet with. In the practical scenario, in our situation, for instance, the fact that we do not have local VASPs and that the the VAPs that are currently being assessed by locals are based in South Africa. The locals who are assessing, those VAPs there, whatever happens in the relationship between themselves, and the VAPs there, will be regulated by South African law, because they have subjected themselves to the jurisdiction of South Africa, because their VAPs are based there. So whatever issues that arise will have to be dealt with there. So this is what then presents a problem for us, because if a local, has issues or in this instance has been conned, in the relationship they have with the South African VASPs, there's really nothing we can do as Eswatini, because the person has left the jurisdiction, gone to South Africa, and decided to, operate from there. So it's the South African law that will apply. Because the issue that arises really is jurisdiction, because even now, with the particular case I mentioned earlier, what gives us jurisdiction in that case is that the gentleman came here to Eswatini and told the people that, I'll trade for you, you'll make lots of money. And the transfers of the money happened within the borders of the kingdom. So that's what gives us jurisdiction. The additional hurdle we have is that we now have to rely on mutual legal assistance to obtain specific evidence, which is in South Africa, and also to get the individual here, we'll have to invoke extradition proceedings, which is another costly process. But where the person has gone to South Africa, they are totally regulated by the laws of South Africa. Thank you, Moderator.
Thank you so much, Mr. Makakula. So earlier, we made mention of some of the regulatory approaches in terms of virtual assets that are adopted by the different countries. So among those who have accepted virtual assets and said, let's allow businesses, let's allow the people to participate in the virtual assets market, some of them have used existing laws instead of crafting new virtual assets laws. They have used the laws that are prevalent in the financial sector to say, now we are going to use this law. Maybe we'll use the Financial Institutions Act, maybe we'll use the Securities Act to define, or rather to regulate or supervise or intermediate any virtual assets related activity. So from the perspective of Eswatini, from Mr. Mdluli's submission earlier, he made mention that now from the trends that they are seeing from the typologies is people, or rather even businesses, there's a possibility of other businesses violating some of the provisions of the existing law in terms of now taking deposits from people and all that. Maybe from a high level, being also mindful of time, we will be accepting questions and comments and even appreciation from the audience through Slido. Maybe we could start inputting our comments there so that we address those questions after the questions of the panel. There any risk, regulatory risk, is there from the risks that we have talked about, from those that you have seen from your different areas of work that violate the existing laws in the financial system that can be used to protect maybe people or to bring into regulation virtual asset service providers? what is it from existing laws that can be used in terms of virtual assets? CBE and FSRA, please.
Okay, thank you, moderator. I think, as earlier mentioned, the activities, the way that the people who are actually luring these people into, luring our Eswatini into trading or investing in virtual assets, they usually request the individuals to deposit money into their accounts. What we have seen when we're doing some of the investigations, as I've earlier mentioned, indeed, Eswatini deposit money into other people's accounts. There is a breach there where people are now taking deposits, and they have not been licensed to do that. And then also, in as much as, I don't know, Mr. Magagula would assist me on this one, in as much as we currently have a legislation, and these virtual asset service providers are to be, to comply as accountable institutions. The expectation is that licensed and then be registered as an accountable institution. So the AML Act raises an obligation for a VASP already. That is an existing law. In as much as we are saying it has gaps in terms of identifying all the different virtual asset service providers. But if you are an exchange, we require you that you register and comply with the AML Act as an accountable institution. And then the central bank has an act that prohibits deposit taking. I think it's the Financial Institutions Act, Section 8 or 7, somewhere the Section 8, yes, that prohibits individuals or natural persons from, or legal persons from accepting deposits without a license. I think that is what I can mention for now. My colleagues can assist me.
Thank you, moderator. Regarding FSRA, it's similar to the central bank. Over and above the AML Act, to be designated whether you are a bank, whether you are a securities exchange, or you are a securities firm, or you are an insurance company, you must be licensed under the relevant laws. So for you to go out there and market yourself that you are providing a financial service, you must be licensed by the FSRA. So if you go out there and market yourself and you sell a service, you are going against the law. And also for the marketers themselves to go out there and market as an individual, you must obtain permission from the authority or from the regulator. So now it means we are having people who are not vetted, whether they are fit and proper to sell those products, and their knowledge can't be established. And all those people that are agents or quasi-brokers are also violating the provisions of the law. And also the products themselves during a licensing phase, they must be vetted. You vet them according to the suitability of the market one, and also vet them also in terms of risk. Because what you're aiming to do, you want to protect the consumers. So if you can't establish the problems or the issues or the risks that are related to the cryptocurrency before they are sold in the country, those who are offering them, they are also violating the law. Thank you.
Thank you so much, colleagues. I think what has come out from the discussions is that the FSRA and CPE are working towards a policy recommendation paper that is regulating, that is first to understand what virtual assets, what are virtual service providers, what are the implications, and so forth. And Lindiwe highlighted that the main purpose of the paper is to propose a regulatory framework and a supervisory framework for Eswatini. And I want to believe that from what we have seen in the space, regulators, prosecution, law enforcement are not just sitting back and saying, let us see, let us wait for the regulatory framework. I would love to understand, I'm sure the audience would also like to understand, what are your different institutions, your respective institutions, doing to prepare themselves for a point where if a regulatory or a legislative framework would come in for virtual assets, your respective institutions would be ready to come and regulate, to come and supervise, investigate, or even prosecute virtual assets related crimes and activities. I will start the side next to me, Mr. Mdluli, and to the end. After this question, we will be moving to the Slido questions. Thank you.
Thank you. The FAU is currently working on a registration framework for accountable institutions. And in the event the virtual assets are licensed in the country, they will be expected to register as just like any other accountable institutions, whereby there will be vetting of their market entry in terms of their directors and shareholders. So I think there will be some form of how can I put it? There will be some form of redress in terms of the risk that they will be posing to the public. It's because they will be registered and their directors, they will be known, and their activities will be, they're expected to comply with the obligations of the AML like any other accountable institutions. And we'll be having a universe or a list of them existing in the country. So in a way, our registration framework will be able to address some of our concern that we're having right now. Thank you.
Thank you. FSRA?
The FSRA, as part of supervision preparedness strategy, has capacitated its employees by enrolling them into the FinTech course, which is Introduction to FinTech, to ensure that everyone understands that now it's no normal business as usual. We are moving from the conventional space, or now we'll be supervising hybrid products. So what the course offers, it gives you an overview of the digital world, and also it touches on the cryptocurrencies and also the different service providers that are operating in the virtual ecosystem. And also within the FSRA, we have officers who've been trained in cybercrime risk management, and also investigation of cybercrime. That is going to help the officers in the FSRA to, if they need to do inspections, because our inspections are almost similar to investigations, and also be able to see the risk and be aware the type of, like the typologies that are there in the cyberspace or visual space. So that's what the FSRA has done, so that when the laws are implemented, or when the regulator for the virtual asset has been designated, you will know what to do, and we know where to start.
CBE.
Thank you, moderator. As the CBE, we have a function that we created. We have a FinTech unit that is looking at all FinTech products that also include virtual assets. We have conducted research. One of the researches that we've done has been done in collaboration with the FSRA that looks at virtual assets, the risks, and also the formulation of policy that would guide us or Eswatini in terms of coming up with the legal and regulatory frameworks. And also we have capacity building that is going on. Our employees are capacitated in terms of fintechs and also supervision and regulation of fintechs, which also includes virtual assets. We've also participated in the National Risk Assessment, which looked at virtual assets, MLTF risks, and that was the aim of also understanding so that we are ready as the central bank, should we are designated, and we are hopefully will be designated as supervisors who are more than ready. And also what is on the pipeline, our future outlook is at a review of our prudential legislations that will touch on your payments and also the exchange supervision regulatory framework. I think that is what we are currently doing. Thank you.
Thank you. Law enforcement.
Well, as Eswatini Police, we have actually trained some of its personnel on cryptocurrency, investigations, and cybercrime. But we have what we are trying to do now is to disseminate that training to the various workstations. As you know, we have over 15 police stations and a lot of posts. So what we know is that when we're talking about money laundering, you won't see the offense in your office here in Bawani. You will see that person who's trying to launder the money into the country in your border gate in Sikunusa. So we realize that we have to also train the people who are at the border posts and the people at the workstations to be able to combat money laundering and virtual assets criminal activity. We are also hoping that with the introduction of the legislation, it will also help in those who are responsible for the legislation to also invest in the necessary resources to conduct the investigations. Because at the end of the day, what we know about cryptocurrencies is that they may say that they are anonymous, but the good thing is that they belong in a blockchain, which makes it easy to track where this money has went. So with the right tools, you are able to uncover who is actually behind each transaction. So we hope this Indaba will help us get more resources to be able to investigate.
Thank you. Prosecution.
Yes, thank you, moderator. Yes, from our end, for me, I've been fortunate that I have been trained by the UNODC on VASPs, and virtual assets, but I have not been trained in the tools, that is the investigative tools. So I think as a country strategy, probably it would be helpful for the prosecution to be trained together with the police on the tools. But from the training that I received, I would be in a position, for instance, in a court situation to lead an expert because I've seen a demonstration of how this works, but I've not actually been trained on how the tools are, work. But I would be in a position to actually lead someone who is an expert in the field in court to ensure that the evidence is presented to the court. The strategy of the office is that more officers will be trained on this area. There are various programs. Right now there is a EU SK project, and I recall that one of the trainings that they are offering relate to VASPs and virtual assets. I'm trying to remember when exactly it's happening, but there will be officers there from the office who will be attending. There are programs by the UNODC. There are also online programs from the FATF. So the idea we have is that we will have to capacitate as much as possible a number in the office to ensure that if by the time, because this is coming to us, so that by the time these are established here, we are capacitated in terms of if cases arise and we have to go to court and prosecute, what would we have to do to ensure that we present the cases before courts adequately. Thank you, Moderator.
Thank you so much, colleagues. There we have it. Our panelists, or rather our respective authorities and institutions, are actually not sitting back, but they are preparing themselves, capacitating themselves so that they can be in a position where they can handle any virtual assets related activity, and whether it's crime, whether it's even policy. Thank you so much, colleagues. Now there we have it. We have some questions from Slido. From a quick scan, I think some of them have been answered. So this, I think, will be a brief discussion. CPE, the first question is to you. It may be, could you attach a value in emalangeni towards virtual assets?
Okay, thank you. As mentioned earlier on, I think I did highlight that the data that we currently have is, what we looked at is not the entire population of the sector, but what we are sitting at in the years 2019, I think I highlighted that it was around 2.4 million, and the rise went to 3 times in the following year. And then as we speak now, in an annual, okay, we do not have 2023 data, but in 2022, we were over 20 million by natural persons. So that is the value at which is moving out through local institutions. May I please just specify that? Thank you.
You want to answer the question? It's a reflection. Okay, I will allow. It should be brief and not vicious.
Yes, moderator. Pepile and Lindiwet asked me not to ask any question.
Or then let's leave it there. And
So
move
I'm
on.
trying to provide guidance on this matter. So the reason why there is a rise in terms of I would say the transactions or the amounts, it is because if the guys from Central Bank will recall, previously the financial institutions were not allowed to process transactions related to VAS. And then after a circular which was issued by Central Bank, it opened room for those transactions to be processed. So year on year, that increase, the transactions will increase based on that. Now our people are seeing that there is a room to move the money. And also in terms of how then do we monitor, are the fees coming back, or are the monies coming back? That's one concern which came. They are coming back, but they are not sent under the name of those service providers. Some of them come in different narrations, so it varies. But it's hard to monitor. If the central bank want to reconsider and close it, we are happy to consider it, to take that into consideration. Thank you.
Thank you so much, Pinda, and we will leave it there. Okay, I think the one on terms of legislation, it has been answered that we currently do not have, and the CPE and the FSRA are working towards making recommendations for a supervisory and regulatory framework. And this one is asking if trading in virtual assets is trading in virtual assets a crime, or the issue is it's not regulated in Eswatini? I'm not sure who to direct this to. AFIU wants to assist.
Okay, thank you, Telu. Yeah, trading in virtual assets per se is not a crime, but some of the activities taking place while trading is prohibited in terms of the law. For instance, the deposit taking, the failure to implement some of the AML obligation, they are prohibited. Actually, they are violating the law. So, in a way, I would say it is prohibited, though not specifically to say it's prohibited, but some of the activities while trading is prohibited in terms of the law.
All right, CPE wants to assist.
If I may, moderator, the question is saying, is trading in virtual assets a crime, or the issue is accountable institutions? That shows or indicates, I don't know how I put it, a policy behind the drive for us to actually regulate and supervise or get into that space of virtual assets. We are not prohibiting, and we are not saying we are not regulating, but rather we are saying we are working towards effective regulation. We are just trying to come up with effective and all-encompassing legal and regulatory frameworks. Thank you.
Thank you so much, Pepile. To the FSRA, do you keep a register of those who approach you for licensing only because they have been asked to state their source of funds? This could be AML CFT threat. I think it's a question and a reaction at the same time.
Thank you, moderator. Okay, when it comes to register, we don't have a register. They are not documented. And the question would be why. Normally, these type of people walk-ins. And then as you try to probe, you then discover that the person doesn't even understand the idea of virtual assets, but likes the idea. Because the person has heard that there are friends that are making money in virtual assets, and then the person, you find out as you talk that the person has constructed a story that possibly I can do better than my friends that are clothing that they're making a lot of money and operate in the open and possibly swallow them. And to have a register of such people, it's like you're having a register of people who are just fishing for information. So we do have them, but as we engage, we just say that they're just fishers in the sea.
Thank you so much. To the police, what evidence is needed by the police to bring these matters to the attention of the DPP And what evidence does the DPP need to fully execute these matters? I think this question goes to you, to the both of you. What is it that it takes for the police to take issues or matters to the DPP, and what does the DPP need to fully execute?
Yeah, well, the investigation of non-virtual assets, it's in levels, actually. There are those simply non-investigations, like whereby one has transferred funds from this public account to that non-public account, which is now usually done mostly by people who do not have criminal intent. They are actually just trying out to see if they can benefit, if they can hide money. They are like fishing, as my colleague said earlier on. But when it comes to the real criminals, those who work in the dark web, you find that they use services like mixers, where they will have numerous, they'll like over 100 accounts to put the money into, and they now eventually will then cash it out to that virtual service provider. So when we are investigating, it's important we sivula leli khethini simbone ukuthi ngibani lo muntu kahle hle. And where we usually like see that is when they have to cash out now the money, which is mostly through virtual asset service providers. So we have to have the KYC documents of those virtual service providers, and we can only get them from those cryptocurrency exchanges, which is it's very difficult because you have to apply the MLA and apply through Interpol. It takes like forever, and you also have to prove that the initial account which the money was stolen from, if it's a fraud, did not belong to the actual person who cashed it out. So it goes back to what I said before, that we are hoping after this Indaba there'll be more resources put into the police, so we can able to buy the tools necessary to conduct all types of investigations.
Thank you, moderator. I think it will really depend on the offense that has been investigated or which we intend to prosecute. The example of the matter I mentioned earlier, you may actually find that there is no relation with virtual assets there. So the evidence really that we would need is that there are people who paid monies to an individual who does not run, who is not a financial institution, that is illegal deposit taking. Because when you go further and investigate there, you might find that that person never even actually invested that money anywhere in any VASP. It was just a way of conning the people so that he could get the money. But in relation to evidence that will require from, in relation to virtual assets, it will probably relate to a money laundering or terrorist financing investigation, which would mean that we would require evidence obtained from the blockchain itself, because ordinarily banks operate on the banking system. VASP operate on the blockchain. So there, it will basically be the evidence of because the person will have the public key, which is the address on the blockchain, And then it will be the evidence from the VASP itself, because the VASP, if there is a court order that is directed to the VASP to say we want information relating to this particular address, the VASP will have the information. Because when you go there to register, you give it's the normal information you would give when you are registering for a bank account. Your full names, address, residential or postal, whatever address that you give. So the VASP will be able then to supply the information to say this address here, that is this public key, belongs to a particular person. And from then you can even get the banking information of the person, because ordinarily people, when they register with VASP, they also link their bank account so that it's easier for them to transact. So that is the kind of information we'll need from the VASP itself. But from the blockchain, of course, then we'll need evidence of an expert who would have used the tool to investigate, like there's a tool by Chainalysis, the reactor, who would indicate to show that the particular address transferred money or received money that would prove, for instance, money laundering or terrorist findings. That's the kind of evidence we'll require. Thank you, Moderator.
Thank you so much, colleagues. Being mindful of time, let me just read the two comments, and we'll attempt to answer to your questions outside of the panel. I hope we can still access Slido even after the panel discussion. We will write the responses there. The first comment in a light mode, I'm sorry, Anonymous, but Anonymous has said we do not report because we feel ashamed to have been stupid to fall off a scam. I have said that everyone is anonymous. And then the other was a suggestion that since virtual assets are here to stay, why not empower the citizens through training to avoid scams? I think what I have noticed, the central bank, the FSRA, has done educational campaigns on social media, on our print media, to try and educate people about virtual asset scams, not just virtual asset scams, but scams in general, how to identify them and how to avoid them. I think the suggestion is more of encouraging the regulators to continue and do that for the people. Ladies and gentlemen, thank you so much for giving us an ear, for being with us. I will allow Pinda to make his comment as we walk down. Please join me in appreciating the panelists. Thank you. Pinda, I will leave you to the MC. She will deal with you. Thank you, Delulego, for the wonderful presentation that you've had. You've been a very good moderator. Thank you to your panel too, your learned panel. The summary of today is that what we've observed today is that the country was generally found wanting in terms of ultimate beneficial ownership identification and verifications. I think this morning was an eye-opener of where we are as a country in terms of the recommendations. We also noted that whilst we have legal arrangements and
such as companies, trusts, there was no legislative framework that addresses the registration of trusts. Trusts are registered by notary publics in the kingdom. The registration sits with the notary public in their individual offices. We don't have an central registry office in that respect. They only get to be registered at the deeds office once the trusts own property. So it is upon us as a country now to look into that regulatory environment, coming up with the law and assigning an office that is going to be responsible to look into that. It is very important in terms of assisting us comply with that recommendation of being able to identify or easily access information when we want to identify beneficial owners. We have noted that some companies have beneficiaries or have shareholders as trusts. And then when you go to the trust, you'll find that the beneficiary, there is a company or another trust, or even a trust that's not within the kingdom, a foreign trust. So we have to ensure as a country that we have systems that will enable us to get to that warm body, the ultimate beneficial owner of that legal arrangement. Now, the Registrar of Companies also told us what he's observed in terms of the risks that come with those legal arrangements. He told us that there's people who defraud, or companies that defraud government using those legal arrangements, and that is not good for our economy as Eswatini. We do want to see our economy grow so that we can all reap the benefits as a nation. He's also mentioned drug trafficking that is now being observed in that space, as well as human trafficking, and because we've noted that the so-called investors, some of the investors that are in the countries using those companies to layer or to traffic their relatives into the country in the pretext that they are investors or conducting business in the country. And we do sincerely hope that they pay taxes, because if they do that and also evade taxes, there's nothing that they would benefit the country, then I'm not sure what they are here for. We also noted that there are legitimate companies that are being used to do illegitimate business. That is a risk that we have observed on the ground, and we are grateful that we have noted that and are going to take action. Now, we note that as a country we're still evolving with addressing issues of ultimate beneficial ownership, and the current Companies Act is lacking in terms of that aspect. The registrar alluded to that position, but what we also noted is that the authorities in the kingdom are currently doing some work on the ground in terms of assisting entities, accountable institutions, in terms of the identification of the controlling people, the controllers of legal arrangements, and the ultimate beneficial owners. The authorities have issued guidelines to try and unpack the ultimate beneficial ownership space in that aspect, insofar as our entities deal with those complex legal arrangements. What we've observed is that we will need a law that will attend to trust, and then we also need a law that will well, the companies bill that the registrar spoke of is going to also attend to the issue of ultimate beneficial ownership, and is going to try and curb the difficulties that we're currently experiencing as a country in terms of verification of ownership in the complex structures. However, we also note that some of the legal arrangements go beyond the borders of the countries in terms of when you start unpacking the layers, you will go as far as some island that you've never heard of. You only hear of it once you are trying to establish that. So as a country, we also need systems, and the collaboration with other jurisdictions is very important in that aspect, in terms of us now verifying in instances where the ultimate beneficial owners are beyond our jurisdictions. We welcome the automation of the registry, the full automation of the registry of companies, and it will help us in terms of eradicating some of the threats and the risks that we have observed here. And the sanctions that come with the bill, we welcome them. As a country, we are hoping that by the time our parliament, our new parliament that we're eagerly waiting to go and vote for, is going to understand what AML is about, and we're going to get that support when we present the legislation for approval through the parliament. So we still have a long way to go in terms of capacity building in that respect as well. Now, in terms of the last presentation we've had under virtual assets, we heard that there's over 26,000 different kinds of virtual asset service providers worldwide, and that in terms of value, it's over $1.3 trillion dollars. And then from the central bank perspective, the banking sector, they've identified transactions going through their system, the exchange control, and that there's no virtual asset service provider currently registered in the country, but we're observing that our fellow Eswatini are currently trading with altcoin and Luna in the neighboring countries. And we've also been informed that year on year there's growth in terms of the activity in that space. However, despite the fact that there is growth in that space, then in terms of the value, what is coming back from that kind of investment activity, it's very minimal compared to what the funds, the outflow of funds in that space. The Eswatini Financial Intelligence Unit has also said that they've received some suspicious transaction reports that show evidence of trading in virtual assets in the country. And what was also observed by the panel is that there is an opening for fraud. The risk of fraud is there, because some people are being defrauded under the pretext that they are trading in crypto, yet they're being exposed in Ponzi schemes in the neighboring countries. The police also, law enforcement also did note that despite the fact that there is no formal report made and there's no formal docket submitted to prosecution, but their investigations and their studies have shown that there is a lot of activity in terms of people sending money to crypto platforms. And so what we have taken away from this session today is that the regulators, the authorities, have acknowledged their responsibility in terms of recommendation 15 when it comes to crypto assets, and that there's a requirement that the authorities must conduct risk assessment, and also another requirement that the crypto asset service providers as well, they themselves also have to also conduct their own risk assessments, amongst other obligations that come with the recommendations. We've also noted that the products, the cryptos, they have agents that are unlicensed. I think the authorities spoke at length in terms of addressing that aspect, that there are certain individuals or companies that come in to sell the product and they are unlicensed, and we've also noted the obligations that the Central Bank and the FSRA Act have, and the Financial Services Regulatory Authority have in terms of attending to those. Central Bank did indicate that they would look into that in terms of illegal deposit taking, because what's been observed is that most of the agents encourage people to deposit into their personal accounts or their company accounts without getting the appropriate approvals from the central bank. So the authorities have the obligation in that regard, and the FSRA legislation also stipulates that any person who sells a financial services provider, a financial services product, has to have a license. So if people are selling any form of financial services product without a license, be they individuals or companies, they are committing an offense if they don't have that license. Now, in terms of the regulatory environment, it was understood that as yet we don't have any laws, we don't have any regulatory framework, and one of the vulnerabilities that was identified is that there's still lack of understanding of that of the crypto space in the country. We do acknowledge the fact that there is currently a policy paper that is being drafted by the authorities that is going to be sent to government, so that a country position is taken in terms of dealing with that line of business. Yesterday, we were reminded of the importance of controlling money laundering in the country and combating terrorist financing. As an ASAMLAG member, it is important for the country to comply with the FATF recommendations. It's for our own benefit as an economy, and also so that we don't get grey listed as a country. I think grey listing would pose a huge dent to our economy. So we need to collaborate and fight very hard so that we don't get grey listed as a country. Now, it was noted yesterday that the mutual evaluation report of the country highlighted a number of deficiencies in terms of the effectiveness, the country's effectiveness in combating money laundering and terrorist financing. Now, in a bid to address those issues, we've embarked on the national strategy, and it was discussed at length yesterday what we're going to do under that. And now, in the national risk assessment, we also, as the draft was presented, it was also observed that the vulnerabilities posed, that were observed, by the team conducting the NRA, was that they were porous borders. The quality of the CDD customer due diligence framework was lacking, and that as a country we were not adequately identifying beneficial owners. And the quality of our criminal investigation was still found lacking, as there was also an observation of a low-level number of cases. We were also found lacking in the aspect of DNF BPs, and the supervision thereof was still found wanting. We have a vast number of that sector, and we still need to attend to those. There was also lack of capacity and information that was identified by the National Risk Assessment in some aspects. Yesterday we also learned on parallel financial investigation. We had an interesting session in the afternoon where law enforcement shared what was expected of them. They did acknowledge the deficiencies that they had observed in that space in terms of now that they would only look at the predicate offense and not then look at the parallel financial crime that went with that predicate offenses. Parallel financial investigation should also extend beyond the borders. We noted that the law enforcement spoke of the fact that they lacked capacitation and resources in that aspect. Now, way forward in terms of what we have undertaken to do through the presentations we had yesterday and to this morning, we have noted that there is an omnibus law. The governor yesterday alluded to that. There is currently an omnibus law that is being drafted, which is a law. The reason why it's called omnibus is because it's going to affect a lot of other legislations. It may be an amendment or an addition to other pieces of legislation. So it's going to address the deficiencies that were found lacking in terms of technical compliance in our mutual evaluation report as a country. And we are hoping that when Parliament comes, they will approve that law. We're going to also be finalizing the National Risk Assessment, following the technical assistance that we've received from the World Bank, who are in a position to review the findings and also implement the corrections that were recommended by the technical assistance that was on site. We're also looking forward to the Companies Act that is coming with not only the sanctions but other requirements in terms of transparency when companies are registered, in ultimate beneficial ownership and the likes. In terms of capacity building, we noted that the law enforcement, that is police prosecutions and other sectors, authorities and our stakeholders, they did mention that we needed capacity in terms of understanding the risks and also understanding what needs to be done, our obligations in terms of ensuring that the country is not grey listed. Collaborations, as we are here discussing, we are here to make a commitment that we are going to be working together to make sure that the country is not grey listed. The authorities, the council, the technical committee, the institutions that are designated to provide those STRs we all have to play our part. We all have a part to play in this agenda to make sure that our country is compliant. Implementing the strategy, there's action items. Some of the action items are for the council, some are for the technical committee, some are for the authorities, and some are for the accountable institutions. Every stakeholder has a duty in that strategic plan. It's going to be rolled out, and we have to do our part there as well. There's also a policy recommendation paper that was mentioned in the last presentation relating to crypto, to the virtual asset service providers. The policy paper is going to be put forth to government so that there is a country position relating to that as to who is the rightful authority to look into, monitor that, supervise that aspect and other things of the like. We've also identified laws relating to trusts that need to be attended to, which is going to be done immediately after the omnibus law. I think in terms of the way forward, I will end there. We have come to the end of the program, and we appreciate comments and feedback, and we kindly please request that you post your comments, your feedback, your questions on Slido, and maybe you can also, when you are submitting your feedback, make recommendations on what you'd like to see going forward, where we can improve as the technical committee, and for the next Indaba, what you would like to see being discussed, or any other observations that you may have had. We thank you. At this point, I would kindly request the CEO of FSRA, Mr. Ncamiso Njali, to come forward to kindly mention a vote of thanks, and also to pray for us. After his prayer, we will have lunch, and then we will be excused. Mr. Ncamiso, our MC from yesterday. I'm not that good as an MC, but he did a better job, so he must come and pray. Atawugudluta lapha ngone khona. I'm sorry I delegated upwards, but I had to.
Siyabonga manje. Judge, ufaka libhuluko angizange ngimbone. Colleagues, the director of the FIU, Leonard, oh, I'm not allowed to say that as well. I have many attorney colleagues. They took me to task in Bitalumyenga Council and said, you don't qualify to do that. And I so want to be a lawyer part-time. We thank you for such fruitful and exciting conversations. On behalf of the ministry, the PS who wants to take us to the central bank, we are grateful for the time that you have set from your busy schedules to engage on these matters. Where we sit in our corners, we consider them to be our bread and butter issues, but when they become at the national scale, like it has been now, we have to also put in much effort as authorities. So the participation of the private sector particularly, and these engagements that have happened today, they are a testament of our progress as a nation, and we thank you for that. Members of council, and on behalf of the council as well, the chairperson who opened with the minister yesterday, we did give him feedback yesterday on how things went, and I am sure he will extend to critical stakeholders his appreciation as well. We thank the central bank. We thank particularly the technical team. They have done amazing things in trying to assist and bring knowledge to the council to determine the agenda on AML CFT matters. They continue engaging with critical sectors in the economy to raise awareness and provide guidance on instruments around AML issues, and their work is recognized, and we appreciate individually and the institutions that they represent. We have come to the close of this second AML Indaba. I would want to believe that we'll keep them flowing. Kungabi ma outputs of a mutual evaluation. We will demonstrate effectiveness that us as authorities, we are friends and chums with the sector. But we also have to demonstrate that we provide the right guidance and we engage on issues of critical importance in the space. We thank you for that. Kunabafundisi la labanye ngithi nangibacela ukuthi bathandaze bale manje nakwalo umfundisi, then ask yourself ukuthi kepha umnikela bawali. Anyway, let us close let us bow our heads and pray. Heavenly Father, we appreciate, we open our souls and our hearts with thanksgiving for the opportunities that you've availed for us to learn and build each other. As a nation, as a collective, we invite you, Lord, to clear our consciences as we enter into this serious election season. We pray for the leadership of this land. We pray for the institutions which are tasked to lead and guide us. And as we depart, Lord, let's remain with the lessons in our heart and the commitment to continue doing good unto others. The food that we're about to take, the hands that have prepared them, we bless them in Jesus' name. Amen.